Welcome to the week after the election. It's possible by the time you're watching this, they still haven't declared a winner of the election yet, which means that the courts may get involved. They've helped decide elections before, like the 2000 presidential election in the case Bush versus Gore. Speaking of the Supreme Court, that's what we're going to finish up with this week. About you all, but I think it's going to be pretty rare moving forward that I ever have a group of students that studies the Supreme Court while a new justice was being added to the Supreme Court. So anyway, you got to be kidding me. I'll be back in a sec. Okay, I'm back. Second one this week. Where was I? Oh yeah, that's right. Anyway, so Supreme Court Justice Amy Coney Barrett was confirmed to the Supreme Court just a couple weeks ago by the Senate. It was a pretty close vote, but nonetheless, she's now on the Supreme Court. When President Trump was trying to pick a new Supreme Court justice to replace Ruth Bader Ginsburg, who had passed away, he talked about all of those things your textbook mentions a president looks at when they're trying to find a new Supreme Court justice. President Trump wanted to pick a woman. He said that from the onset because he wanted to kind of appeal to women. After all, there was an election coming up very soon. Besides the political factors, Trump also looked at her resume. She had a very impressive track record in law school at Notre Dame. She was a constitutional law professor, and she was a judge on the U.S. Circuit Court of Appeals, which we'll talk about today. So she had a track record that showed that she was an originalist in terms of her judicial philosophy. On top of that, President Trump knew that he had the votes he needed to in the Senate because the Senate's controlled by Republicans in order to get her officially nominated. If Democrats controlled the Senate, he would have had a very tough time getting an originalist on the court. He would have had to pick a very moderate judge. But all that considered, it led to Amy Coney Barrett becoming the next Supreme Court justice onto the Supreme Court. It means conservatives or originalists have a 6-3 majority on the court. Speaking of judicial philosophy, there's two other ways to categorize judges in terms of their judicial philosophy that we don't really talk about in regular government that we do dive into in AP government. The first one we'll take a look at is called judicial restraint. Judicial restraint is the philosophy of constitutional interpretation that justices should be cautious in overturning laws. They defer to the judgment of the legislative and the executive branches. They believe that the elected bodies represent the majority rule, and ruling against them sets an undemocratic precedent. They believe that judges are not policy specialists, but legal and constitutional specialists. They believe that the complexity of execution of decisions is beyond their scope. So to put it another way, these are judges that don't really believe it's their responsibility to be making new policy from the bench. They believe they should kind of go based off of what the court has said before, called precedent. And they also believe that they should kind of defer to the legislative branch. Unless it's egregiously against the Constitution, trust them to do what they want because they're the elected majority that was elected in by the people. So judges that believe in judicial restraint restrain themselves from making new policy because they believe in separation of powers. It's the job of the legislative branch to make new policy. On the flip side of that, you have judicial activism. Judicial activism is a judicial philosophy of constitutional interpretation that justices should wield the power of judicial review, sometimes creating bold new policies. Other branches make mistakes or they trample over rights and liberties. Often, this type of philosophy tries to protect minorities by striking down the opinion of the majority. Justices are free from concern about the popularity of their actions because, again, the judicial branch is independent. And this has been active in the courts in the 1960s in striking down discriminatory state laws that restricted civil rights. Now, this is speaking broadly, but typically judicial restraint is associated with more conservative judges that Republicans like to pick, and judicial activism is associated more with liberal judges that Democratic presidents like to pick. I say broadly speaking because sometimes judges don't always vote on a case the way that you think they would based off of their judicial philosophy. Unlike in Congress, where members have to adhere to the strict party line and there's a high degree of partisanship, which means usually there's a high degree of unity when it comes to voting on things, judges are independent, so they can go back and forth on different issues depending on the facts of the case. The Supreme Court doesn't really have parties or leaders, which means unlike in Congress or with the president, they don't have someone that might threaten to punish them if they vote outside of party lines. In fact, it's not uncommon for a Supreme Court justice that was appointed by a president to then rule against that president's actions in some way on the court. In fact, if you take a look at this chart, it shows you how Supreme Court justices align with their appointer. And you can see the one that's the highest is only at 66%. Now, we always give a lot of attention to the Supreme Court, and rightly so, because they're the highest court in the land. But there's actually a ton of other courts that are part of the judicial branch at the federal level that we never really give any attention to. But those matter because most cases don't make it to the Supreme Court. They're actually ruled upon by those lower courts. So I want to take a little bit of time to explain the life cycle of a case and how it makes its way up to the Supreme Court. First, it's important to know that there's two different types of law. Both state and federal courts have jurisdiction over two categories of law, criminal law and civil law. Criminal law is a category of law covering actions determined to harm another person or the community, and government will then try to prove guilt of the defendant. Now, there are state laws and federal laws that vary when it comes to criminal law, and sometimes they even contradict, in which case the court has to resolve the contradiction. Then there's civil law, and that's a category of law covering cases involving private rights and relationships between individuals and groups. So this would be things like divorce proceedings or property disputes, whereas criminal law is more so things like theft, assault, robbery, or even rape or murder. Now, the vast majority of criminal and civil cases are handled and decided by the state courts. State court structure consists of trial courts of original jurisdiction, appellate courts with appellate jurisdiction, and state Supreme Courts. And it is important to note that state judges are often elected or appointed depending on the state that you might live in. In Ohio, most of our judges are elected, unlike at the federal level. Let's say that, God forbid, you get involved in a criminal or civil case and it makes its way through the state court system and you want to appeal the case to the federal courts because maybe it involves a federal issue. Well, there's a way you can do that, and there's a system in place for how that case will make its way all the way up to the Supreme Court. So you can think of the federal court system as kind of like a three-layered pyramid. The lowest level is the federal district courts. So once a case makes its way through the state courts, this is the first level it goes to in the federal system. These are trial courts in the federal system. They handle most of the work and they have original jurisdiction. There's 94 total federal district courts. And the middle level is the federal courts of appeals. There's 13 of these total, and they have appellate jurisdiction only, meaning they review the decisions made by the district courts. Then, of course, you have the top level. That would be SCOTUS, the Supreme Court. And they resolve differences between the states. They resolve different interpretations of the law. And there's only one court, and they have both original and appellate jurisdiction. Since 1869, they've only had 9 justices. Since Republicans hold control of the Senate, it seems unlikely that number is going to change anytime in the next few years. Now, as for which court specifically your case goes to really largely depends on your geography. So here's a map that shows you the district and appellate courts as they're spread throughout the United States. Now, as I was going through that whole system, you may have gotten confused when I said the words original jurisdiction and appellate jurisdiction. Just a reminder, original jurisdiction means that that court has the authority to hear the case first. Appellate jurisdiction means that the court has the authority to review the decision of another court and overturn or revise that decision. And just like with the Supreme Court, the president gets to choose judges to go on to these appellate courts and district courts, and they have to be confirmed by the Senate. And the confirmation process for lower courts is not nearly as high profile as the confirmation process for obviously the Supreme Court, where the media and everyone pays attention to it because it's the Supreme Court. The lower courts kind of get forgotten about. A big reason the confirmation process for the lower courts is so smooth is due to something called senatorial courtesy. Senatorial courtesy is when the president consults and gets the approval of the senator from the state or the district in which the new judge will rule. The rest of the Senate, upon seeing this, will vote to approve the judge since they will only impact that particular state or district. So basically, the president picks a judge and then tells the senator whose district that will be over, yo, you good with this person? And if the senator says, yeah, I'm cool with them to be judge, then the rest of the Senate will basically go, all right, well, if you trust them and they're just going to be making decisions that impact your district and not our constituents, then cool, sure, we'll vote them in. Yeah, you can't find senatorial courtesy listed in the Constitution. It's not in there. It's just kind of been an informal tradition or custom that's evolved over time. Now, it is possible for Congress to create more district courts or to create new appellate courts as well. That's one of their delegated powers in the Constitution. That's one of the forgotten checks that the legislative has on the judicial branch, because if you can create new courts, that means you can add new judges, which means you might impact the outcome of some of the decisions. Creating more courts can also impact the caseload the Supreme Court has and how often they're able to actually make a decision on something. In fact, one of the first major laws that Congress passed was the Judiciary Act of 1789. And that is where Congress created the structure of the lower federal judiciary and set the number of justices on the Supreme Court. So they created the district courts with original jurisdiction, then the courts of appeals with appellate jurisdiction, then of course the Supreme Court, which is the only court that's actually officially mentioned in the Constitution in Article 3. Speaking of Article 3, let's go back and take a look at Article 3 real quick. I mean, it's not that long anyway. All right, let's see here. Judicial power of the United States, vested in one Supreme Court. Congress can make inferior courts. Judges shall be good. Let's see what else it says here in Section 2. Judicial power to extend to all cases under their authority. Controversy between two or more states, the citizens of the state and another state. Something about ambassadors. Trial of all crimes except in case of impeachment shall be by jury. And then something about treason. Wait a second. Where does it say in there that the Supreme Court has the power to strike down a law or an action of the president as unconstitutional in there? What's that? Oh, this just in. It doesn't. That's right. Article 3 of the Constitution never says the phrase that the Supreme Court has the power of judicial review, which, if you remember, is the power to strike down laws and actions of the presidency as unconstitutional. It's not mentioned in there. It does mention like what the Supreme Court has jurisdiction over. Like, for example, it says in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction, period. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, but there's nothing in there about judicial review. It's not specifically mentioned in there. So how on earth did the Supreme Court get the power to strike down laws as unconstitutional? I still haven't been able to figure out why the Founding Fathers never specifically put the phrase that the Supreme Court has the power of judicial review in Article 3. But I do know how they did eventually establish it. It's a little case called Marbury versus Madison, which is one of your required AP Supreme Court cases. And this one is kind of difficult to understand. So that's why I'm not only going to assign you something about it, I'm also going to go over it in the video here. So let's set the scene, shall we? The year is 1801. John Adams and the Federalists had just lost the presidential election to Thomas Jefferson and the Anti-Federalists, who at this point were called the Democratic Republicans. But John Adams and many of the Federalists in Congress were still lame ducks, meaning they had not yet left office and the new administration had not yet taken over. John Adams and the Federalists came up with a sneaky idea. Of course, as you remember in Article 3 there, it says Congress can create new courts, new lower courts under the Supreme Court. They're called inferior courts. So John Adams and the Federalists created a bunch of new courts, and John Adams appointed a bunch of new Federalist judges to those courts, hoping, of course, that these new Federalist judges would strike down a lot of the policies that Thomas Jefferson and the Democratic Republicans, their arch nemesis, would try to implement. So John Adams appointed the judges and the Senate confirmed them, and Adams signed off on it. So good to go, right? One problem though. In order for the judges to officially start their job as judges, they needed their commissions to be signed and delivered. And commissions basically saying, here are the judges and here's what their job is. Somehow, someone procrastinated and those commissions never got delivered. So Adams leaves office and Thomas Jefferson comes in, and Thomas Jefferson appoints James Madison to be his Secretary of State. And James Madison goes into the office and he finds these commissions just laying on the desk. So he tells Jefferson, hey, Tommy, these commissions have just been laying on the desk. They haven't been delivered yet, which means those judges obviously can't start their jobs yet. Jefferson's like, oh, really? And Madison says, well, should I deliver them? And Jefferson goes, heck no. So Jefferson and Madison never delivered the commission. And one of these midnight judges, a guy by the name of William Marbury, was pretty angry. Marbury was upset because that meant he wasn't going to get his job as a judge. And I kind of sympathized with him because we know how long and tiring that whole confirmation process can be. And he basically went through it all for nothing. So Marbury sued James Madison and demanded that the Supreme Court issue a writ of mandamus on Madison. And a writ of mandamus basically means that the court is mandating you to turn something over. In this case, the commissions. Essentially, Marbury is suing James Madison, asking the Supreme Court to force Madison to turn in the paperwork. So the case goes to the Supreme Court, and Chief Justice John Marshall has a pretty difficult case in front of him. So William Marbury's lawyer goes into the court and says, okay, all right, so let's take a look at the Judiciary Act of 1789. As you'll see, Your Honor, you notice in here there's a line that says that the Supreme Court shall have original jurisdiction over cases requesting writs of mandamus, which is what my client, Mr. Marbury, is trying to ask you all for. And so, Your Honor, since we went through the entire constitutional confirmation process, Mr. Marbury deserves a writ of mandamus to be issued by this court to have his commission delivered. John Marshall said, all right, we'll hear the other side of the case. So the lawyers representing James Madison said, oh, that's real cute how they used the Judiciary Act of 1789 to bring that up, but you guys don't actually have the power to issue writs of mandamus. It's not mentioned in Article 3 of the Constitution. In fact, Your Honor, if we read Article 3 of the Constitution, we'll see it says, in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. But as you can see, Your Honor, cases involving a writ of mandamus are not included in the list of cases that feature original jurisdiction. So, Your Honor, we have here a conflict. The Judiciary Act of 1789 says the court can issue the writ of mandamus via original jurisdiction, but the Constitution doesn't say the court can. Therefore, we have a conflict. So whenever we have a conflict, we must ask ourselves who is right. And Your Honor, if I may, direct your attention to Article 6 of the Constitution and the Supremacy Clause. The Supremacy Clause states the Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made which shall be made under the authority of the United States shall be the supreme law of the land. So, Your Honor, this case was brought to you through original jurisdiction, meaning that they wanted you to pick the case up and be the first to rule on it. And they're requesting a writ of mandamus, but Article 3 of the Constitution doesn't say that you have jurisdiction when it comes to writs of mandamus. Therefore, Your Honor, your court cannot even hear this case. So after hearing both sides, Chief Justice John Marshall and the rest of the justices on the court get together in their conference and they discuss the case, and then they emerge with a unanimous ruling in which Chief Justice John Marshall says, okay, first, y'all, we don't even have the right to hear this case. We have no original jurisdiction over cases involving writs of mandamus. It's not mentioned in Article 3 of the Constitution, and the Judiciary Act of 1789 tried to give us that power, but they can't because the Constitution is supreme over the law via the Supremacy Clause. Therefore, because it's not mentioned in the Constitution, the Judiciary Act of 1789 is unconstitutional. If you want to give us this power per the Constitution, you must add a constitutional amendment. You can't just pass a law saying that we have this power. Constitution is supreme via the Supremacy Clause. So, Marbury, you should get your commission, but it would be unconstitutional for us to give it to you. So to summarize that for you, Congress, with the Judiciary Act, tried to give the Supreme Court a power that was not expressly given to them in the Constitution. And as we know, if you want to change the Constitution, the way you need to do that is by making a constitutional amendment, not by making a law. In this case, we had a law that said the court had a power that the Constitution didn't say that they had. So whenever a law is in conflict with the Constitution, due to the Supremacy Clause, the Constitution wins out over the law. So Chief Justice John Marshall said, yeah, Marbury, you should get your commission, but we can't issue a writ of mandamus demanding them to give it to you. The significant thing about this case is that it established judicial review. It was one of the first times the Supreme Court struck down a law and declared it unconstitutional, which is what judicial review is. So if there's any confusion or any doubt about whether or not the Supreme Court had the power to strike down laws and presidential actions as unconstitutional, Chief Justice John Marshall put it to rest. By striking down the Judiciary Act of 1789 as unconstitutional, he expanded the power of the court and gave it a legitimacy to where it was now a co-equal independent branch within the federal government. Marshall's ruling established the precedent that the court had the power of judicial review moving forward. As we wrap up Chapter 6 on the federal judiciary, there's a few terms I really want to go over because I have a feeling they're going to pop up on the AP exam because they do pretty much every year. All of these terms use Latin phrasing, and the first I can never pronounce. It's called a writ of certiorari. Certiorari? Certiorari. We'll just call it a writ of cert. A petition for a writ of cert is basically asking and requesting the Supreme Court to hear a particular case. Remember, the Supreme Court doesn't have to hear every case that's requested to be heard by them. So most of the time, the Supreme Court tries to choose cases to hear that have big constitutional implications that haven't necessarily been settled yet. A writ of cert is basically a petition trying to show the reasons why the Supreme Court should take that case on and actually hear it and rule on it. Once the Supreme Court decides to hear a case, they may then begin to receive amicus curiae briefs. Amicus curiae brief is often from an outside source from the case that tries to offer up some expertise and some legal advice and some opinions that might help the justices in making a decision on the case. Sometimes interest groups like the ACLU might offer up their expertise on a particular issue that's coming before the court via an amicus curiae brief. Once the Supreme Court starts hearing a case and they get to the point where they're trying to make a decision on the case, they'll often rely on something called stare decisis. Stare decisis is Latin for to stand by things decided. Stare decisis is when the Supreme Court uses precedent. That means a previous ruling from a previous case over a similar issue that's before them to help guide their decision making with their particular case. Oftentimes that means they'll let a previous legal decision stand. Now, do judges on the Supreme Court always have to go by stare decisis, and do they always have to go by what the precedent is? No, as you all know from history class in Plessy versus Ferguson, that precedent that was established about segregation being okay as long as it was separate and equal was overturned in Brown versus Board of Education. So stare decisis and the idea of using precedents from previous cases over similar issues is there to bring about some consistency to the court and help guide the judges in their rulings. And that, ladies and gentlemen, wraps up our unit on the Supreme Court. Hold on a second. Hello? Wait, so we're going to be talking about the Supreme Court all year? There's a unit on civil liberties and civil rights? We're going to keep learning about a ton of Supreme Court cases? Supreme Court mock trial? Guess we're not done with the court. Besides memorizing all of this for the AP exam, you're going to want to remember how the court works, because in January, whether we're here in person or online still, I do intend to try to do some sort of a Supreme Court mock trial where we go through like an actual case and you all are the justices. Reminds me, actually, the class is now at 9, which means we have a full Supreme Court. As justices, you all will get an amicus curiae brief, actually from Mr. McNichol and the administration here at CTEC, and then we'll actually have oral arguments followed by a conference where you all decide on the case, and then you write up your either majority opinion, concurring opinion, or your dissenting opinion. But before we get to that, we've got to go through our units on civil liberties and civil rights, so you can use stare decisis on the Supreme Court cases we learn in those units to help you decide that case I'm going to give you. And I'll tell you, it's a tough one. Hopefully there'll be some sort of a vaccine for COVID and we'll finally get to come back to school sometime this winter to do that. Speaking of COVID and a vaccine, I wonder what part of the federal government's in charge of overseeing that. Hello? Wait, there's a fourth branch of government? They're overseeing the vaccine? That's what we're going to learn about next week? So this week, you've obviously got this Ed puzzle, and then you have a perusal video, this time on Marbury versus Madison. Don't forget about that Supreme Court outline cheat sheet I gave you where you can take notes on the Supreme Court cases so that you can study easier for the AP exam in the spring. Then, of course, you've got the rest of Chapter 6 to outline as well, plus one added bonus assignment this week you can do that is totally optional. That'll do it for this week. Reach out if you need anything, and have a great week.